Mississippi. The Fifth Circuit Court of Appeals, and in the United States Supreme Court. She has also served as adjunct faculty at USM and assistant dean for student affairs at School of Law. She has been inducted into the Constance Slaughter Harvey Black Law Students Association Hall of Fame and the Council on Legal Education Opportunities Judges Hall of Fame. She has a bachelor's degree in business from USM, a master's degree in business from UNO, and a Juris Doctor from School of Law. She is the mother of one son, Gabriel, who is a JSU alumnus and a member of Kappa Psi fraternity. Judge Polk-Payton was born and raised in the city of Hattiesburg in Forest County and believes in giving back to the community that nurtured her into adulthood. She is very active in the community and has received countless recognitions. She has spoken and sang at events for USM, William Carey, Jones County College, Fellowship of Christian Athletes, American Cancer Society, American Heart Association, Alpha Kappa Alpha, Omega Psi Phi, the Masons, the NAACP, Hattiesburg Public Schools, City of Hattiesburg, Forest County, National Association of Drug Court Professionals, and the list goes on. She is a member of Delta Sigma Theta sorority and West Point Church. She has also received many community awards, including the Martin Luther King Jr. Drum Major of Justice Award, the Social Justice Award from Zeta Phi Beta, Martin Luther King Jr. Community Service Award from Alpha Phi Alpha, and the Alumni Spotlight for Hattiesburg Public Schools. She is also a singer, songwriter, published author, former radio show host, and a blogger. Let's welcome our speaker for today.
Good morning, everybody. Good morning. Can everyone hear me okay? My name is Gay Polk-Payton, and I'm going to be talking to you guys today about estate planning. And like Sarah Ducksworth said, this is a difficult thing to talk about, but it's a necessary thing to talk about. If you are just joining us, you can put any questions that you have in the chat box. And if you want to take some notes down, just get yourself a pen and paper. I'm going to try to talk as slow as I can. I do speak a little fast, but I'm going to talk as slow as I can to try to give you an opportunity to write things down. If there are some words that sound a little convoluted, I'm going to spell them for you so that you'll be able to get them down, because I like to try to break things down to a language that's common to everybody. But some of these terms are just what they are, and there's no other term to describe them. It just is what it is. And the purpose of this is not for you to be ready to die or for you to be anxious to die. It's just for you to be prepared to die. I mean, it's just everybody dies. It's like I heard a preacher say you were born dying. I mean, and it's a real concept, it's a real phenomenon, and we have to really just understand that and have a situation where our family is ready. So I don't profess to be an expert on estate planning. There is a man in Hattiesburg who any lawyer in Hattiesburg will say is an expert. His name is Kearney Travis. He's an older gentleman. I think Mr. Travis may be 85, but he is an expert on trust, land, estates, anything you have about that, he's gonna know, be able to answer your question off the top of his head. So he's the only person that I will personally say in public, in front of anybody, is an expert on estates, wills, and property law. I wrote down some little bullet points just so I can make sure that I cover everything. But like I said, if you think of something while I'm talking, just put it in the chat box and I'll stop and try to answer some questions as we go along. When I was in law school, I took property law. I took wills and estates, and I took future interest and trust. And what future interest and trust is, that just means the things that you leave to other people, the things that are going to be future interest that other people hold after you've passed away. That's all a future interest is. And a trust is just money that you put away for somebody who may not be old enough to hold it themselves, and you have to put it in trust of a bank or of a guardian, someone who can hold it for them until they're old enough to get the money themselves. I'll talk about that a little bit more as we go along. But when I was in law school, my property law professor, he walked us down to the courthouse and showed us how to do a title search. I mean, that's how serious he was about us understanding how the law works and how property is passed on. And that was very helpful to us. I mean, that was one of my B pluses in law school, because I really understood it, I grasped it, and I was able to digest it in a way that it stayed with me, and it's going to stay with me forever. It's something that, you know, things just pop into my head whenever I think about it. Okay, so let's see. One of the reasons that I don't practice law in estates, I will do estate plan. I will help people do a will or do a deed. I will do that. But the reason that I don't like to do after someone has died estates is because it's a lot of work. And because it's a lot of work, lawyers charge a lot of money. That's why the things I'm going to tell you today are going to help you to get things done before you die. Because if you get things done before you die, it's a whole lot cheaper than on the back end. I mean, lawyers charge around $10,000 to probate an estate. And if you get it done on the front end, you know, you could pay less than $2,500 to get it all done. And, you know, and if your assets are only just some money in the bank at a house, you've just caused your children to waste $10,000 to get assets that may be worth a little bit more than that. So if you handle things on the front end, you will save your family a lot of drama. So, you know, my parents were, you know, they were very strong. They were strong parents. My mama was my rock. I mean, she was my rock. And when she passed away, you know, that was the hardest thing that I've ever had to deal with in my life. And when you're going through grief, that's enough. I mean, it's like when your children are dealing with your death, that's going to be enough. So don't leave them to have to deal with how they're going to bury you, or fighting over who's going to get what. Oh, mama wanted me to do this, mama wanted me to do that, blah, blah, blah. Don't leave them in that position. Have your wishes, make your wishes known before you die, because once you die, nobody's going to know what you think. And the law is going to take over, and you won't have anything to say about it anymore. So while you have an opportunity to say it now. And another thing about that, don't wait until, if you have elderly parents, don't wait until your parents are old to do it, and wait until, you know, maybe if someone has dementia or something like that, to do a will or to do a deed, because the first line says, I, whoever their name is, of sound and disposing mind. So that means they need to know what they're doing. And the notary has to ask them, do you know what you do? Are you of sound and disposing mind? So the person has to be of sound and disposing mind in order to transfer property and in order to create a will. So make sure you don't wait until, you know, your parents are too old to understand what they're doing before you try to start transferring property. You know, it's a difficult subject to talk about with your parents, and I understand that. But if you are a parent, you want to deal with this situation for your children so that they won't end up dealing with things after you're gone. Now, let me see. If you die without a plan, like I said earlier, you will have the law to do it for you. And I'm going to talk about what happens when the law takes over. That's what I'm going to talk about a little bit more. First, you got to figure out what's in your estate. Okay, if you want to make a plan for your estate, you got to figure out what's in your estate. And some people have a lot of stuff in their estate. Some people are you know, they balling. They got houses in different states. They got intellectual property. They wrote books. They got songs. They got music. They got all kinds of intellectual property. They got stocks and bonds and all this stuff that they have to bequeath to someone else and have to pass on after they pass away. So when you have all of that stuff, then estate planning on a large scale is absolutely necessary. I mean, you have to do it on a huge scale. You have to make sure that everything is stated exactly how you want it to be done if you have that much stuff. But I'm just going to be real with you. The average citizen has a house and some money, and that's pretty much it. Some jewelry maybe, but mostly the big things are a house and some money and maybe a car, you know, and it's just like, that's what the average citizen has to leave. Maybe a retirement account or something like that. But, you know, retirement accounts and life insurance policies, they have beneficiaries on them. So you know who that's going to go to. So you don't have to even really deal with that. But if all you have in your estate is a house and some money, then what you do is you prepare a deed for your house. I'll give you an example. My house is in my name. I have a life tenancy, and I'm going to explain to you what that means in a little bit. A life tenancy in my house, that means this is my house as long as my life exists, as long as I am alive. This is my house, with remainder to my son. So as soon as I draw my last breath, this house belongs to my son. He doesn't have to do anything. This is his house as soon as I draw my last breath. So the remainder is his, it's his house, and he doesn't have to do anything extra. Same thing with my bank accounts. My bank accounts are POD to my son. What that means is payable upon death. Payable on death, because upon starts with a U, but payable on death. That's what that means. When somebody dies, that money goes. So it immediately vests. So when I die, the money in my bank account belongs to my son. So all he has to do is take a death certificate up to the bank, say, my mama died, I need to get this money out of this account. And he gets the money out of the account, and he don't have to run around, you know, forming GoFundMe accounts trying to find money to bury me. Well, he's not going to bury me anyway. I'm going to be cremated. I want to be set on fire like King Arthur, but that's another story for another day. But he don't have to run around trying to find money, because people do that all the time. You know, they're looking for money to bury a loved one. And that is so, so hard when you're already dealing with the grief of losing that person and you can't get the money. They got money in their account, but you can't get it because your name ain't on the account. So like, and there are no concerns with POD. Now, there's a difference between POD and a joint account. So if I had a joint account with my son, then it would be, he would also get it as soon as I died, because it would have rights of survivorship. But the difference between a joint account and a POD account, the joint account, he can go in and write a check on my account right now. But the POD means he can't touch my money till I'm dead. So that's the difference and the distinction that you need to make, and let the bank know, I don't want a joint account. I want a POD account, so that they cannot touch your money until you are dead. And that's a very important distinction to make, because if you do a joint account, they will be able to access your money while you're alive. It will go to them once you're deceased, but they'll be able to get it, you know, today if you do a joint account. I love Kobe, but it ain't going down like that. Okay, so that's when you need to determine, once you determine what's in your estate, that's how you'll determine whether or not you need a will. And like I said, some people will need a will. Like if you got a whole lot of stuff in your estate, the things that I listed before, you may need a will, and it'll be a good thing to have a will. But sometimes you just don't need one. You can just do a deed, and you could do a POD, and it's done. I had a client, and she called me and she wanted to do a will. She had 2 sons. And what she did was she wrote down who she wanted to have her pearls, her jewelry, all her stuff. She wrote it down in her handwriting and signed it and said who she wanted to have her stuff. And then she got me to handle, to prepare some deeds. She wanted one son to have this house and the other son had his land over here on the other side of Hattiesburg. And so when she died, those sons called my office, and they said they couldn't. They said my mama said that you did some deeds for her when she was living, but we can't find them. I emailed them those deeds, and that was it. It was already done. That was their land. They didn't have to do anything else. So it's just like she handled her business, and it was so easy. She wrote down all her personal property, who she wanted to have. That's called a holistic will. HOLI. I can't spell it when I'm saying it out loud. HOLISTIC, holistic will. When you do a holistic will, that means it's penned in your own name, in your own handwriting, and then subscribed in your name at the bottom. And when holistic wills are contested, they bring in a handwriting expert and they'll find something that you signed at the bank or something like that and bring that in to see if the handwritings match and see if there's the same handwriting. And that's what they'll do at court when the will is contested, if it is contested. So, but that's for your personal property. You can do that. Like I can say, I want my furniture to go to my niece Lauren, and I want my jewelry to go to my niece Leslie, and I want this to go to so-and-so. And I can bequeath it to them in my handwriting if it is personal property. I cannot do that with real property. What is real property? Real property is houses and land. You cannot. Now, let me make a distinction here. A mobile home is personal property. When I say houses and land, I mean land and a house that's attached to the land. A mobile home is not attached to the land most times. So I'm not talking about a mobile home. A mobile home that if you can hook it up and drive off with it, then that's personal property. So, but land that cannot be passed with a holistic will. It cannot be passed with pen and paper. You have to pass that with a deed. You have to prepare a deed, and it has to be notarized. Your signature has to be notarized to pass property with a deed and pass land in a deed. So make sure that you understand that distinction. And if you want to write down your personal property, you can, when you start writing down, I want so-and-so to have this, and I want so-and-so to have my land, that you can't write that down. You have to get a deed prepared to pass your land on, and to pass your home that's on the land. Now, understand this. When you do a deed, the deed will say, and I don't know if you've ever seen a deed. A deed it's so convoluted. It'll say, I hereby, for good consideration and blah, 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 I hereby convey unto this person the land described as starting at the northwest corner of the southwest corner of the blah, blah, blah. It just goes on and on and on. It's a mess. But you have to have that exact description. It has to read exactly as it said, township for north, all of that. It has to read exactly as it reads on the deed. Otherwise, you are not conveying the correct piece of property. But when you do that, you have to make sure that when you convey, you got to make sure that you have that land description exactly. You can't have a letter off. You can't have anything off. Everything has to be read exactly as it's stated in the previous deeds or as it's recorded at the Chancery Court. Otherwise, you will not have a valid deed. So just understand that when you do a deed and you pass property to someone, that deed will also say, and all appurtenances thereunto belonging. What that means is appurtenances thereunto belonging. And what that means is any houses that's on it. So that means that the land and any houses that's on it. So you can't separate the house from land. So it's like if there's a house that's built on that land, if it's a mobile home, you can drive it off and do whatever you got to do. But if it's a house that's attached to the land, then that's an appurtenances belonging to the land. So that deed is going to say all appurtenances thereunto belonging. So you are conveying that house when you convey that land. And I'm going to talk about that a little bit more. I don't know, is that in my, I'm going to talk about that a little bit more in just a few minutes when I talk about siblings, because it just gets so crazy when parents don't deal with this before they die, and then the heirs are just going crazy because like he's on my piece of land. But I'm going to talk about that in a few minutes.
Sarah Payton.
Yes, ma'am.
We do have a question in the chat.
Okay.
Can a holistic will be typed and signed, or does it specifically have to be handwritten?
It should be handwritten. The entire thing should be handwritten. That's what makes it holistic. Holistic, and as what it means is in its entirety. So it needs to be written out. Because anybody can type what they want to type and then get mama to sign it. That's why it's important for it to be holistic, for it to be entirely written.
Thank you.
Is that it?
Mm-hmm.
Yeah, it needs to be entirely in your handwriting. Okay, so when I was talking about POD earlier, you can make your account POD to whoever you want to. Like if you want to make your account POD to the funeral home so they can pay for your funeral services, and you've already went over there and told them what you wanted, and you have it paid for or whatever, or you can go ahead and pay for your funeral at the funeral home. They allow you to do that, and you can also have the insurance company to they can pay out of the insurance proceeds. They can pay for the funeral out of the insurance proceeds. So there's so many ways that you can do that. But I have a law office. So my son is not a lawyer. So I have to have my law office account POD to another lawyer, because I cannot fee share with someone who is not a lawyer. So what my law office is POD to another lawyer. And once that lawyer has settled my debts, any bills I had outstanding to be paid, any clients that needed to be paid out of my trust account or anything like that, then he can give the rest of the money to my son. So that money is POD. So that will be taken care of automatically. I talked about how intellectual property and stocks and bonds, you can have for retirement accounts and stocks and bonds, you can have a beneficiary for those as well. Intellectual property, you just want to have a will. When you have that kind of, when you got that kind of stuff, you just want to have a will that says, I want my intellectual property to belong to this person, like this person had. You got to pass that on. You got to say who you want that to go to, because you remember all that drama that was going on after Prince died, and who owned this and who owned that, whether it was his, and I'm going to talk about that too when we talk about heirs at law, because when you die without a will, or you die without giving your property to someone before you die, then you have to deal with the law taking over and deciding who gets your stuff, and who will get your stuff will be your heirs at law. So I'm going to help you know who your heirs at law are, so you'll know how to deal with that and deal with it before you die, just in case you don't want your heirs at law to have your stuff. Okay. Now trust, a lot of people are like, what is a trust? A trust is like, if you have a child who is like, my son is 24. Well, he'll be 24 Wednesday. And the thing about it is, he's responsible. He's a college graduate. He's working on his master's degree. But, if I die and he gets his insurance proceeds, he may not handle it the way he needs to. So, you put money in a trust and be like, okay, so you can have this amount now that I'm dead. And then in 5 years, you can have this. And then, you can have an allowance for them. You can even set up a monthly allowance for someone in a trust. And you can set it up through a bank if it's enough money. Banks won't do it unless it's enough money. So you can set it up through a lawyer. You can set it up through a friend. You can have someone who holds that money in trust as a fiduciary for that minor child, or for that child who is too young to appreciate the value of money, who will spend it like it's water, and then they're going to be broke by the time they're 30. So you can do that. You'll set up a trust to make sure that the kids don't spend their money too fast, because that happens so often. So often. So let's talk about heirs at law. heirs at law it's a very simple, it's a simple concept, but it gets messy. It can get messy when you get married later in life, when you have what we call in the country sets of children, and it can get messy. So say for instance that I die and I have, well, right now, if I die right now, I have one heir at law. I have my son. He is my only heir at law. But say for instance, I die and I had a husband and I had 3 children, then I would have 4 heirs at law, my husband and my children. If I had no children, then my husband would be my only heir at law. If I had no husband and no children, then my parents, if they were living, and my siblings will be my heirs at law. If my parents and my siblings predeceased me, then it will go on, and my parents, because my parents' children are my siblings, so it will go to my siblings' children. So it's just going to go down the line until it's, because you know how people will have money coming from a great uncle that they didn't even know existed. And that's how that happens, because nobody else is alive to get the money. And so that's how that happens sometimes, because they are the only living heir at law out there. And so it just depends who you have alive, who will be your heir at law. Okay, so yes.
We're gonna go back to trust.
Yep.
We have a question in the chat about trust.
Okay.
Do you need to have a social security number to set up a trust for a minor? And what additional information is needed for a trust?
Now, that's going to depend on the bank. You probably do need a social security number. I don't know exactly what the bank is going to need, but if you're setting it up with an individual, with a person, then you may not need a social security number. It just depends on how you're setting it up, but I would not recommend setting it up just haphazardly. I would recommend you get a lawyer to set up the trust and have the fiduciary, sign a notarized document, understanding their duties as a fiduciary. So basically letting them know this ain't your money. So that they will handle it the way they need to handle it. So I would not set up a trust unless I did it with a bank or I set it up through a lawyer. So either set it up through a lawyer or set it up through a bank, and they will tell you everything that you need, but that fiduciary, whoever's going to be holding that money for that child or for that person who is not of sound mind, that person will need to sign a notarized document understanding their role and their duty as a fiduciary. Okay. Now, what I'm about to say now is going to hurt a lot of people's feelings, because when I did the live video, I had so many people inboxing me about this. And, the bottom line is, it's just, the law is the law, and a lot of people get mad with chancery judges about this. You cannot bequeath children. You absolutely cannot bequeath children. You cannot leave your child to your mother. You cannot leave your child to your friend. You cannot do that. Children cannot be bequeathed. If you die, the assumptive custodian of your child will be that other parent. So, it would just behoove you to, make sure that your child at least knows that other parent, because if that other parent is not proven to be unfit to raise that child, then the assumptive custodian, and they want the child, that you got to assume that they are not unfit and that they actually want the child. The assumptive custodian of those children or that child will be the other parent. So, this happens so much. I remember there was a judge that got so much grief. It was even in a newspaper because the mother died in a car accident. And the grandmother wanted the kids. She wanted the kids to stay with her. The kids wanted to stay with her, but the daddy wanted the kids. He wanted his kids. And the judge there was nothing saying that the daddy was unfit. And the judge gave the kids to the daddy pursuant to the law. That's the law. The grandparents got visitation, but the daddy got custody of those kids. And that's what thus says the law. And I mean, it just is what it is. I mean, and that hurts people's feelings so bad, because I mean, they don't want to think about leaving their child with their baby daddy or their baby mama. And I get it. I had a bad mammogram one time and I was in tears because I didn't want to think about leaving my baby, because I know he needs me. And so, especially at that time, I think he was probably about 10. And I was like, Lord, please don't let me leave my baby. He needs me, and it's just like, I was terrified, not of dying. I'm not afraid of dying. Y'all know that because of the way I'm always hopping on and off planes. But I was terrified about leaving my son. That is the thing that was terrifying me. And so I understand. But I do understand that if my son was a minor child and I died, he was going to live with his daddy. That was the bottom line. That was it. And I've seen situations where step parents were virtually raising that child. They were virtually raising that child, and then their spouse died. When their spouse died, those children go back to that parent that they weren't living with. And there's nothing that step parent can do about it, because that step parent is no longer even related to those children. You no longer have standing because you're not even a relative of those children anymore. And that's just the law. And that's why it's just so important to, try at least to forge some type of relationship with the absent parent and your children. Not just so they will know who they are through that person, but so that if something happens to you, God forbid, that your children will not be going to live with a stranger.
I have several questions in the chat about
I'm
this.
sure I got a lot of questions about that. I knew that was coming. Come on.
So the first question is, what if parents of one child die simultaneously? Who gets custody at that point? That's the first question.
Well, they can petition the court. People can petition the court for custody, and then the court will decide who will get custody. Like if the grandparents petition for custody, or if the sister petitions for custody, a sibling of the deceased person. It just depends on, sometimes the court will have to decide who's going to get these kids. But it's going to be up to the court. There's the grandparents will have the highest standing to get the kids if they want them. But a sibling of the deceased parties could get the children as well. So it just depends. But it will be most, and then if there's nobody who wants the kids will become wards of the state, and then somebody would have to adopt them. So it just depends on the circumstances, how that will go. But it will be up to the court to decide.
Okay, so you may have answered this question, but I'm gonna ask it anyway. If the grandparents are the legal guardians and the fathers gave up their parental rights and the mother is deceased, what can be done?
If the father gave up his parental rights, then he's no longer the assumptive parent. If he gave up his parental rights, but giving up parental right, guardianship is different from adoption. You have to understand the difference between adoption and guardianship. Guardianship just means that you watching over these kids while their parents can't. If just in case their parents can't do it, you watching over them. But an adoption means that that parent has given up their parental rights. They are no longer related to that child. Once they give up their parental rights, they are no longer related to that child. That's not their child anymore. Their birth certificate even changes when they get adopted. So if that parent has gotten his parental rights terminated and the grandparents have adopted that child, then that's their child when the mama dies. But if they're just guardians over the children and the father has not terminated his parental rights, those kids are going with their dad. So it just depends on whether it's an adoption or whether it is whether it's a guardianship and whether or not he's really given up his parental rights.
And the next question, when you have legal physical custody based on the divorce decree, how do you handle the legal custody?
What do you mean? How do you handle the legal custody? I mean, it doesn't matter who has custody. If you die, that child is going, the assumptive custodian is going to be the other parent. It don't matter who has custody. You can have all the custody. You can have primary physical But when you die, that child is going to go, the assumptive custodian is going to be that parent unless somebody comes into court and shows that they are unfit, or unless that parent signs a joinder and a waiver saying that I don't want this child. That's pretty much, you know, the gist of that.
Okay. Those are the
All
questions.
right. Okay, you got any more questions? I'm gonna try to get through all this material. How much time we got? We got a little bit more time.
That was it.
That's it?
Yes.
Okay. All right, y'all. So I wanted to help y'all to understand it. I'm going to go into some other stuff, but I'm going to try to cover the gamut of everything. And then at the end too, I'm going to take questions again. So if you have questions, keep typing them. I will answer every question. I will answer every question. I don't mind being interrupted with questions. I just want to make sure we get everything answered. And you with the legal and physical custody question, if I didn't answer your question, then make it more specific, and I'll answer it if I didn't answer it. Okay, so this is a huge thing. I even talked about this in my book, dying while you married to somebody else. This is huge. I mean, this happens so much when you die, but you married to somebody else. I was in court one day, and there was a couple that I knew from my neighborhood when I was growing up, and they were trying to get a divorce. And I was 28 at the time. I was a baby lawyer. I just started practicing law, maybe 29. And I'm standing there in court, and they're up there trying to get a divorce. And the judge was telling them that they had done some stuff wrong with their paperwork. And I said, Your Honor, may I approach the bench? And he said, yes, yeah, come on up, Miss Payton. And I went up there. I said, Your Honor, I'll fix it. And he was like, ma'am, I said, whatever's wrong with that paperwork, I will fix it. And he was like, well, he said, well, okay. He said, well, y'all go with Miss Payton. He said, whatever she charges you to fix this paperwork, you know, y'all pay her. I said, Your Honor, I'm 29 years old. I said, they've been separated since I was 5. I said, if nobody else in this courtroom needs a divorce, they need one. I said, I'll fix it. I'm not charging them a dime. I'm not charging them anything, because if he would have died or she would have died, and he could have been with somebody else, he could have been living with somebody else and all of that, but she would have been one of his heirs at law if he died, or he would have been one of her heirs at law if she died. And they've been separated for more than 20 years. I mean, it's insane, but that's how it is. So often, more often than I would like to think about. Like, people just sit on it. They just separated, and you know, you live with a man, and I mean, they'll live public lives. They'll be with other people publicly, and you know, you with your man, and he got a wife, and you living with him, and then he mess around and die, and then you just out of luck, and his kids come over there. You think you living in his house, and then his kids come over there and put you out because it's not his house anymore. He died without a will. You not on the deed with remainder. So now that's his kid's house, and they finna come put you out. So it's just like, you can't live like that. You have to make sure that the people in your life have handled their business, and make sure that you're not in a situation where you're going to be left out in the cold when something happens to the person that you love. I got an example for you that everybody knows about. You remember when Eric Garner was killed by the police in New York? Eric Garner was the man who was choked by the police outside with the cigarettes outside of that store in New York. When they had a lawsuit against New York, and when the lawsuit was settled and they got the money, Eric Garner was still married. He was living with his girlfriend. They had a baby together. They had a whole child, and they living together. And he and his wife hadn't been together in years. They had children together, but grown children, but they had not been together in years. He was living with this woman, and they were happily together. But when that lawsuit came down, the baby mama girlfriend, she didn't get a dime. Now her baby got some money, but she didn't get a dime. And the money that the baby got is going to go into a trust. The court is going to put that money in a trust for that child, because they're going to have to settle that claim for that minor, and they're going to put that money in a trust fund for that child. And she's not going to get anything unless Eric Garner had a will leaving her some money, or if he had a deed on the house they were living in with rights of survivorship. I'm going to tell y'all about that in a minute. Leaving her the house, then she got nothing. when Eric Garner died. She got the same money that she had the day before he died, or the day before that lawsuit. She didn't get anything. So they may give her some money to help her raise that child. You know, they may give her an allowance from that from the court, but it's not going to be much. But they got millions of dollars, and that money went to his wife. She was one of the heirs at law. Because when you have heirs at law, if you got 5 of them, they're going to split that money 5 ways. But she was not one of his heirs at law, so she didn't get a thing. Her child did, but she didn't. So make sure your man or your woman handles their business if they are, in fact, still married to someone else. I don't care how long they've been apart. It doesn't matter. So I'm going to talk about the types of tenancies. That's what I was talking about with the house, if he had joint tenancy on the house. And the types of tenancies you can have is joint tenancies with rights of survivorship. That's how married couples usually do it. It's like they'll have the man and the woman with rights of survivorship. Lisa and Michael Smith, joint tenants with rights of survivorship. That's usually how married couples do it. And so that means when Michael dies, the whole thing goes to Lisa. And when Lisa dies, the whole thing goes to Michael. So that's usually how people do it. The problem comes when someone gets married later in life and maybe they refinance the house that their children grew up in. And they refinance the house. And then now she's married to, because her and Michael had it is joint tenants with rights of survivorship. So Lisa got it over here. But now Lisa done married Anthony Jones. So now the house is joint tenants with Anthony and Lisa Jones, joint tenants with rights of survivorship. Same house, but different owners with rights of survivorship. So now Lisa dies and Anthony owns the whole thing. So she has just disinherited her children from her house and land because they're not going to get any part of it. No part of it, because she's done joint tenants with rights of survivorship with her new husband. So you have to be very careful about when you refinance, when you do different things, when you get married later in life. You have to be very careful about how you handle that to make sure that if you want to leave something to your children, that you do it the right way. Now, what she could have done, because I mean, you know, Anthony, he's paying on the house too, so he deserves to have a part of it. But what she could have done was to do a tenants in common. Now, when you do tenants in common, that means you own your half, I own my half. So when I die, my half gonna go to my heirs at law. Your half gonna go to your heirs at law. So I have not disinherited my children. So that means that my kids gonna get my half, your kids gonna get your half. That's how you do it if you don't want to disinherit someone who might get your part. Because otherwise the whole part is gonna go, if you do joint tenants with rights of survivorship, the whole part is gonna go to the other person. You can do what I talked about earlier, which is a life estate. That's what I did with my house, where I gave a life estate to myself with remainder to my son. And his remainder will be what they call fee simple ownership. That means he owns the whole thing, fee simple ownership. And so he will have that once I die. That's how he will own the property. And if he wants to do a life tenancy in him and will remainder to someone else after I'm gone, he can do that. He can do whatever he wants to do with the property. And I'm going to talk about that in just a few minutes about what happens to your property and your debts when you die, because this is very, very, very important. Very important. Because when it comes down to land, the deed takes off. You know, the deed, it don't matter what your will say, the deed is gonna rule. And Mississippi is a race notice state. So it's like whoever's deed gets recorded first, that's the one that's gonna rule. All right, heir property. We have so many issues with heir property because people don't understand how it works. So when you have family land and you have you got a house out on your mama and daddy land, but you don't own the property. They've never deeded that property to you. You just built a house on your dad's land. Your mom and daddy got a house on the land. Your brother got a house over there on the land. And y'all all got a house. Your brothers and sisters, some of your brothers don't have, some of your brothers live somewhere else, but you know, a couple of you and your brothers got houses on your mom and dad's land. But they've never handed you, they've never deeded that piece of property to you and made it yours. If your mom and daddy die, that land is heir property, which means the entirety of that property belongs to all your brothers and sisters. And when I tell you, when I told you about the deeds, all improvements and appurtenances thereunto belonging, including your house, everything that's on that property, when a deed is passed, all improvements and appurtenances thereunto belonging. So that means that that property that your house is sitting on and your house belongs to everybody that are your parents' heirs at law. So what you need to do is, if you have a house on your parents' land, you need to go talk to your parents. You know, be like, I ain't trying to rush you to die, but just sit down and talk to them and tell them, can you can you get a surveyor to come out here and partition this land? Tell them I'll pay for it, but get a surveyor to come out here so we can partition this land, and you can give me a deed to this part of this land where my house sits. Because if you don't and your parents die, then that land is going to belong to all your brothers and sisters, all of them. So, I mean, because I've had so many people say, he's trespassing on my piece of the property. Let me see the deed. That's the first thing I say. Let me see the deed. I'm like, he can't trespass on it because it belongs to all of y'all. That's what I say. Like, it just is what it is. And I'm like, heir property is so messy. It is really, really messy, especially when it's a bunch of kids. You know, when people, because back in the day, people had 10, 11 kids. And when you got all those kids and you have not planned your estate, you know, it can be messy when you have 4 kids. So, you know, it just is what it is. But when you have children, you have to plan that, because what's going to happen after you die, and you got your kids got that, you know, one child gonna want the family home, and you know, this child gonna want his home over here, and your child gonna want this home over here, and then your child had to move to New York, and blah blah. They gonna come down, try to run everything, and it's gonna be a hot ghetto mess. And I mean, you know, sibling rivalry is a mess. I mean, brothers and sisters have killed each other over this kind of stuff. I had a situation back when I was a baby lawyer where a girl and her brother were in court, and she was trying to probate her daddy's estate. And so my client and I entered an appearance because she didn't notice him. So when we saw it in the newspaper, which I'm going to explain that too, we saw the newspaper, he saw the newspaper, so he came and hired me. So I entered an appearance as his attorney, and to contest, you know, her taking everything. And so she told the judge, this ain't my brother. I don't know whether or not he's my daddy's child or not. He ain't never had my daddy's last name, blah, 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 blah. I don't know whether he's my brother's or not. So the judge entered an order to exhume the body. We had to exhume this man's body out of the ground so that the medical examiner could draw some DNA, and they could do a test against my client's blood and his blood, and, you know, find out whether or not it was his daddy or not. So it was his daddy. And the money that after they got through paying for that exhumation, paying for all those attorney's fees, she ended up getting less money than she would have gotten if she would have just shared that money with her brother. So go ahead and name your heirs before you die. Go ahead and name the people that you want to have your stuff before you die, because there may be some people who you don't want to have your stuff that end up with your stuff when you die if you don't say it. So if there's somebody who will be your heir at law that you don't want to have your stuff, like if you got a child that you don't want to have your stuff when you die, or if you don't have any children and you don't have a husband and you got a brother or a sister that you don't want to have your stuff, you don't leave them out of your will. You leave them $1. Because if you leave them out of your will, they can come in and contest it in court and say, I think he accidentally left me out. And the court could take that into consideration, and they could end up getting some of your estate. But if you leave that person $1, the court will know that you have acknowledged that this person exists, but you don't want them to have nothing but $1. So that's the way you handle that. If you want to disinherit someone, leave them $1 so that you will, just in case it ends up in court, they will have been acknowledged, and you will know that the court will know that that person exists. We got some questions?
Yes. If the siblings agree to how they're going to handle the heir property, does it still have to be probated?
No, it does not have to be probated. If they can agree, what they can do is they can get a surveyor to come out there, which is so much cheaper. Wait a minute, hold on. How is the land listed though? If the land is still in mama and daddy's name, then it does have to be probated.
Still in parents' name, still in the father's name.
If it's still in the parent's name, yes, it has to be probated, because it has to be put in the brothers. You have to be. I'm gonna give you a perfect example. That was in my notes somewhere else, on my next set of notes, but I'm gonna go ahead and tell you the story now. My parents died within 17 months of each other. My daddy died 3 weeks before I graduated from law school, and my mama died 17 months later when I was pregnant with Kobe. Okay, so a year after my mother died, our house burned to the ground. We lived on J.C. Killingsworth. It was Ashford Street then, but our house burned down. So but my parents had insurance. The house was paid for, and there was insurance on the house. And in order for us to deal with the insurance company, my mother and father didn't have our names on anything, so we had to set up an estate. And I was a baby lawyer. I hadn't had a chance to do anything. I had just become a lawyer. I was pregnant. I just hadn't had a chance to do anything to help my parents deal with estate stuff. So, and when my daddy died, I wasn't even a lawyer yet. So I went to go and do a title search, because remember I told you my professor walked us down to teach us how to do a title search. So I went to the courthouse to do a title search on my parents' house. So I went to do a title search on the house, and I found out that my mama's name was not on the house. Only my daddy's name was on the house. So what I had to do was I had to probate my daddy's estate to have my mama and us named as my daddy's heirs at law. I had to probate my daddy's estate to have my mama and us named as his heirs at law at the time of his death. Okay. After I probated my daddy's estate, then I had to open my mother's estate and have us named as her heirs at law. Then I was able to deal with the insurance company with the money, but not until I had my mama named as my daddy's heirs at law, because her name wasn't on the deed. So the names have to be right on the deed, because it's heir property until then. And the reason that is because you have to do a notice to creditors in the newspaper, and you have to publish this so that if there are any heirs out there, because especially if it's a man, there may be some children out there. The court presumes that there may be some children out there that may want to enter an appearance and say, this is my daddy too. And, it could happen. So there are procedures that have to be followed if that property is still in the name of a deceased person. That's why it is so important for you to make sure that before you die, you put that property in the name of the person that you want to have it. Because if you don't, then the law is going to take over, and y'all can't agree until that property is in y'all's name. So what's going to happen is y'all going to have to probate your parents' estate. Depending on how it was listed, you may have to probate both of their estates, because you can't probate their estates together. You have to probate their estates separately based on who died first. And then, like I did with my parents. And then after that, you can, if one of your parents is still living and they had joint tenants with rights of survivorship, then that living parent can deed it to the siblings, and y'all can partition it like that. But if both parents are deceased, you're gonna have to probate the one who died first, and then you have to probate the one that died next. And then the court will give will give ownership to the heirs. of the property. And then at that point, then y'all can get a surveyor out there and agree on the partition and how y'all gonna partition it. Or you can get the court to get a surveyor to go out there and partition it and say how it's gonna be partitioned. But I mean, it's just like, I experienced this. That's why I feel so strongly about it. I experienced how hard it can be to try to deal with things after someone has already gone. It's really a lot to deal with. Do I have any other questions on
Yes,
that?
ma'am. Does paying the taxes on the land change the right to use or ownership on air property?
It depends. Like, you can redeem the taxes on property for 3 consecutive years and get a chancery court deed under certain circumstances, but you know, it just depends. If you paid the taxes for 3 consecutive years, there's a way that you can get a chancery court deed and make it your property. But you got to talk to the chancery clerk about that. I'm not giving that kind of legal advice on this Zoom.
What do you do when people who have no rights to heirship, siblings, parents, etc., break in and take what doesn't belong to them? The deceased being married with offspring.
You call the police. I mean, if they don't have any rights to the property and they broke in and stole something, that's residential burglary. Call the police. That's all I can tell you to do about that. You call the police and press charges. Okay.
I do have one more question.
Okay.
I have paid taxes for our county for 10 years and it is still a state property to heirs. Is it still a state property to heirs?
It is, unless you follow certain steps. And I just talked about that a few minutes ago. You're gonna have to talk to the chancery clerk about what you have to do to redeem the property and to have it declared yours. But I just call the chancery clerk. They'll talk to you about that. Okay, so let me tell y'all something real quick that's very important for you to understand, because a lot of times people will have a power of attorney, and a power of attorney, you know, is good to have, but even a durable power of attorney, people like, because a durable is D-U-R-A-B-L-E, like durable, like tough. Durable power of attorney is what makes it durable is that it lasts after you are no longer of sound and disposed mind. That's what makes it durable. But what it won't survive is death. A guardianship, a power of attorney, and a conservatorship, all of that dies with you. So none of that stuff will survive your death. So you have to make sure that you have your business handled in form of transfer and title, and have a will going on before you die, because I'm about to tell y'all how it goes when you open an estate. That's my next topic, is talking to you about how to open an estate, because you can't transfer anybody's property once they're dead. You can't use a power of attorney, a guardianship, or a conservatorship to transfer anybody's property once they're gone. Because once they're gone, that power of attorney, that guardianship, that conservatorship, it dies with them. So make sure you know that, so you won't be breaking the law, because that will be breaking the law. That will be fraud. So do I have any other questions before I go into opening the estate?
No, ma'am.
Okay. All right. So opening estate, there are 2 types of estate. You got a testate estate and an intestate estate. Testate, T-E-S-T-A-T-E, testate estate. That just means you had a will that's going to be probated. That's all testate means. Intestate, I-N-T-E-S-T-A-T-E, means that you don't have a will. So that means that the court is going to be determining who your heirs at law are, so that they can figure out who's going to get your stuff. That's basically it for that. So what you have to do, hold on. Okay. What you have to do when you have an intestate estate or a testate estate, and you may have a brother, sister that lives off, and they don't want nothing to do with the property. They don't want to deal with it. They happy with it, or they don't want the property. They just want to go on with their life. And so if that happens, then what you want to do is you want to get them to sign a joinder. And a joinder is just saying that I'm joining in with this. I'm waiving all my rights. You know, they can join in and say, you can have me named as an heir if they do want something. Or they can say, I'm waiving all of my rights to the property. I don't want anything. You know, y'all can go ahead and have it all, blah, blah, blah. But you want to make sure that every heir is accounted for, because you have to make sure that every heir is named and make sure that everybody is accounted for. Now, once you open an estate, you file a petition to open the estate. But once that judge signs that order, open the estate, the next thing you got to do is a notice to creditors. That notice to creditors runs in the local newspaper 3 weeks sequentially. The creditors have 90 days after that third running to make a claim on the estate. So that means your estate is wide open for everybody you owe, including student loans and back taxes, everything you owe. 90 days, your estate is wide open for them to come and say, you owe me this, you owe me that. And that means they could take every dime that you got, because, you know, you may owe more than you actually have in your estate. So, and they can, you know, and if you owe too much, you know, they can levy it, and then you have to sell the house in order to pay the bills and all that stuff. And then you end up with nothing. Your children end up with nothing. And that's why you need to go ahead and deed it so that it'll be theirs when you die, and your bills won't be levied against their ownership of that property. It'll be their property, not yours, and your debts won't go with it. So, but there are debts that you can't escape. Like, for instance, if my son wants to keep this house, I'm gonna leave it to him. But if it's not paid for when I die, then if he wants to keep it, he's gonna have to keep paying the mortgage, unless I have credit life on my house. If I had credit life on my house and they paid my house off when I died, then that would be a different story. Then they would pay my house off, and then he would own it, you know, fee simple ownership with no encumbrances, no liens. But, and then if he wanted to keep my car, he would have to continue to pay the note on my car. Unless it's like, because I got a pickup truck that don't have a note on it, then he'll own that outright because it doesn't have any encumbrances on it. It doesn't have any liens on it. But if my car has a note on it, he's gonna have to continue to pay that note if he wants to keep it, unless it has credit life on it that pays it off when I die. So that's important to know. Those are debts that you cannot escape. But some of your debts, you only open yourself up to if you open an estate. So if you deal with some of this stuff before you die, you won't have to open an estate. I'm just saying. All right.
You have one question.
Okay.
What can be done to obtain a spouse's information, such as bank account with only one name on it, without I'm assuming this is a POD, a POA, but POD when that spouse has a stroke and is no longer competent?
Say that one more time.
What can be done to obtain a spouse's information, such as bank account with only one name on it, without a POD when that spouse has a stroke and is no longer competent?
Okay, what you have to do is you have to go and file a petition for a conservatorship. And you can do that. A conservatorship is just a power of attorney that's done by the court. That's all it is. Like, if you haven't gotten the power of attorney before that person became incapacitated, then the court can do a conservatorship. And it's just, all it is a guardianship power of attorney. That's all it is. That's done by the court. And so what it'll do is the two doctors will say, this person is not fit to handle their business. So I think that this person should be appointed to handle his business. And that's what you would do. You would petition the court to open a conservatorship to handle, so that you'll have the legal right to handle their business. That's how you would handle that.
Thank you.
Let me see.
Polk-Payton?
I talked about a lot of this stuff. You got another question?
No, ma'am, we have 3 minutes left. So I don't know if you want to wrap it up or start another topic, because we're definitely going to need a part 2.
Okay. So I think I've covered most of this. One thing that can be done after someone dies is a small claims affidavit. If you need to get the money out of the account, if somebody is dead and you can't get to their account and you know they got some money in the account, you can get somebody to draw you up a small claims affidavit so that you can get the money. But it's just better to handle things while you're alive. Okay, even with the advance directives, while you're still able to do it. Because you never know, you may end up in a coma, you may end up incapacitated for some reason or the other. So you want to do an advance directive with your doctor, with the hospital, to let them know, because your kid's gonna be fighting. I want mama to stay on life support. No, mama don't want to live like this. Tell them what mama wants before you are incapacitated or before you're in a coma. Let them know what you want. And in that way, they don't have to fight about it. It'll already be known. I promise you, when my father passed away, we were headed down to the country to bury my daddy. And my mama looked around the funeral car and she said, don't y'all bring me down here when I die. I mean, make your wishes. And she's up on Mount Island Hill. So make your wishes known before you die, so that you will, so that it will be known to your children, known to your heirs, and put it in writing. And if it needs to be notarized, then put it in a notarized document or put it in a holistic document. But the thing you got to do is admit that you will die. You got to admit that to yourself. And like I said, when I first started this, don't be anxious to die. Don't be ready to die, but be prepared to die. Thank you for your attention. Any questions?
No questions, but we did have one wanted to know, could you give the last steps of opening an estate without explaining them? So I guess kind of bulletproof it.
Oh yeah, sure. Okay, so when you open an estate, you file a petition to open an estate. And then after that, the judge will sign an order opening the estate. If there are brothers and sisters, they will sign a joinder. If they're not signed on that petition with you, then they will sign a joinder joining into the petition with you. If they don't want anything out of the estate, they can sign a waiver saying that they don't want anything out of the estate. Once the judge signs that order opening the estate, then you will do a notice to creditors in the newspaper it'll run for 3 weeks. And then after that third one runs, the creditors have 90 days to put a claim on your estate. Once those claims are done and everything is done, then you can file a petition to close the estate and to disseminate assets. And then the judge will sign an order, depending on how simple or complex the estate is, the judge will sign an order closing the estate and disseminating the assets. And that's basically that's the basic, way it goes. Sometimes it's a little more complex, but that's how it goes basically. Any other questions?